can be either one or the other. Both cannot survive.
And anecdotally, it is said that it's one grave, either you or me, either Zia or Zulfikar Ali Bhutto. So General Zia had the entire state machinery at his disposal. And when I take your lordships to the judgment of Supreme Court, sir, 78 paragraphs were written by Supreme Court to justify the bias of Lahore High Court. Where in the world would you need 78 paragraphs on 24 pages of Supreme Court judgment to say that...
What are you talking about?
Zulfikar Ali Bhutto's judgment in Supreme Court, I'll take your lordships. It enumerates the allegations of bias. So it took Supreme Court 78 paragraphs
To say there was no bias.
to say that there was no bias. What more evidence of bias does one need?
I also think, if
74 paragraphs.
I also think, if I'm not wrong, that this judgment is the longest criminal judgment in Pakistan's history. Is that so? It's 900 and something paragraphs.
Indeed,
How many paragraphs is it? Do you have it before you?
Yes, sir, I have, sir.
Because I've never read such a long criminal law judgment.
So it starts from page
No,
53.
just see the last paragraph. How many paragraphs? I think it's 900 and something. So because civil constitutional matters do go into such details, but criminal matters... I think it was 953 if I recollect. Anyways,
935.
935. Now, who's the best criminal lawyer in the courtroom? 935? 935. तो इससे ज़्यादा कोई लंबा जजमेंट हुआ है क्रिमिनल लॉ में या ये दिस होल्ड्स द रिकॉर्ड?
सिर्फ बायस पे आप देखिए
नहीं,
पैराग्राफ.
मगर ये इतना लंबा क्रिमिनल लॉ का जजमेंट, क्योंकि आमतौर पे गिल्ट यू हैव टू एक्विट और कन्विक्ट, मतलब यू जस्ट कंसिडर द एविडेंस.
इससे तो ये लग रहा है कि वो खुद भी कन्विंस नहीं थे इतने ज्यादा डिटेल देने से.
एग्जैक्टली. इन कैमरा ट्रायल पे सर उन्होंने लिखे हैं पैराग्राफ्स जो इन कैमरा ट्रायल पे सुप्रीम कोर्ट ने 171 पेजेस 33 पैराग्राफ्स इन कैमरा ट्रायल को जस्टिफाई करने पे लिखे.
It reminds me of a case in the House of Lords where it said we had a good prima facie case. The lawyer went on for about half an hour. He said if you had a good prima facie case, I guess you would take half an hour with it.
Indeed.
So, okay, I don't know whether anything builds on that.
So when you lordships will go to the details, a paragraph from Lahore High Court where the learned judge said Mr. Zulfikar Ali Bhutto is not a good Muslim. Now what has that got to do with the criminal trial? And the Supreme Court justifies that he should not have said, but so what?
Khan Sahab, देखिए,
Who said that?
Mr. Justice Aftab in Lahore High Court.
Said that?
And this, yes, sir.
दिखाएं वो कहाँ है?
So ये है page PLD.
I don't remember that.
PLD 78, Lahore, page 53. Approved at 663. Paragraph 609.
At 663.
663 पे Lahore High Court, para 609. And Supreme Court found nothing wrong with it.
Paragraph कौन सा पढ़ने?
So मैं 609 अगर पढ़ लूं,
जी.
at page 663, the principal accused is the arch culprit having a motive in the matter. He has used the members of Federal Security Force for personal vendetta and for the satisfaction of an urge in him to avenge himself upon a person whom he considered his enemy. For his own personal ends, he has turned those persons into criminals and hired assassins and thus corrupted them. Indeed, it is paradoxical that the ruler of a country with Islam constitutionally declared as its state religion, enabling the Muslims to order their lives in the individual and collective spheres in accordance with the teaching of Islam as set out in the Holy Quran and Sunnah, and its declared objective, the guaranteeing of the citizens their life and liberty, should play with their valuable life of a citizen so whimsically and tyrannically. The constitutional provision presupposes that before a person ventures to seek election to the office of the chief executive of the Federation, he would order his own life in accordance with the injunctions and teachings of Holy Quran and Sunnah. Before undertaking to observe the principle of democracy...
This is the main criminal trial.
This is the main judgment of the Lahore High Court. So before undertaking to observe the principles of democracy, freedom, equality, tolerance and social justice as enunciated by Islam, he should inculcate these qualities in himself.
Are you trying to build the case that the mere such expression finding place in a criminal trial judgment itself constitutes bias? Is that your point?
Indeed.
Or is some other point you're making?
This is the focus, this is the thrust of the submissions.
And how was this paragraph considered by the Supreme Court?
It was considered by the Supreme Court.
And how was it sustained or repelled?
The particular para I'll point out. Para 910.
I find it very strange in a criminal case.
And it was totally unnecessary.
I mean, 9 and 10.
PLD 79, Supreme Court, page 53, Supreme Court judgment, para 910.
अब सुप्रीम कोर्ट का भी मुझे इनायत कर दें. ये 2000 PLD कौन सा है?
The PLD 79 Supreme Court starts with 53. At page 384.
अब छोटा ऑर्डर कौन सा इसमें दो है ना? डिटेल
Detailed.
जी
जो 53 से शुरू होता है.
Page 384.
Page 53 से शुरू होता है.
नहीं, आप कहाँ से पढ़ना चाहते हैं?
384 से.
पढ़िए.
Paragraph, last paragraph 910.
पढ़िए.
In paragraph 610 to 16 of the impugned judgment of the High Court has made gratuitous observations about the personal belief of the appellant and delivered a sermon as to the mode of conduct prescribed by Islam of a Muslim ruler. It is also stated that the appellant was a Muslim in name only and that he had abused his powers under the Constitution. I am inclined to agree with the learned counsel that the observations in these paragraphs were not necessary for the disposal by the High Court. In this connection, however, the learned counsel further submitted that these observations and remarks about the appellant disclose the extreme hostility and bias entertained on part of the learned trial bench against the appellant. It, however, appears to me that the High Court had found the appellant guilty along with other co-accused on the merits of the evidence adduced in the case. Its findings to that effect were not influenced by any such extraneous consideration. In fact, it was only towards the end of the judgment that this discussion occurs, and the conclusion was drawn in proposing the punishment as stated in paragraph 617 that the appellant was thus liable to deterrent punishment. Although even for this limited purpose, also these observations were not strictly relevant, yet they did not thereby vitiate the order of conviction of the appellant, which was not based on any such extraneous considerations. Now, I can't think of any one of your lordships today writing this paragraph in this particular context.
What I need to understand from you, Mr. Khalid Khan, is the court might have given bad judgments, wrong judgments over the years. Then the facility of review was available. So this particular statement that you refer was available, and review could have been filed against that. As I understood from what Mr. Makhdoom said, that when we're looking at this jurisdiction, the one that we're talking about, you're looking at the case in a totally different perspective. You're not looking at the merits, you're not looking at what happened, because that was already settled. You had all the grounds available, you could have raised it in review and settled it. Like this, every bad judgment and every wrong judgment would be open in this case. So it is whether at all there was due process, and that would mean whether at all the judges were independent enough to decide this matter. So this matter was properly adjudicated and fair trial was granted. So all, as I see it, you have to establish before us that either all or one judge was not independent. And that led to a mistrial kind of a argument. But and if you could refer to the material available to establish that the judge was not independent. I mean, I don't understand any other argument. There is no other way that you could say his judgment is wrong unless you show that the bench itself at that time could not possibly have adjudicated the matter fairly without bias. And you'll have to show some material Because it's a big, tall order. You're telling the Supreme Court of Pakistan that they were under pressure and they were deciding a matter which was something that they were under pressure and they could not independently decide the matter. You have to show me that material. Because otherwise we keep on opening
Khan Sahab,
everything.
I've addressed this
Khan Sahab, if I, in a way, it may be responding to my learned friend with respect, but one of the due process requirements is, inbuilt in every due process requirement is that a judge must be free from bias. Now, I think what you are showing to us is this: forget the material that I may show before you. These are judges talking themselves, writing themselves. Are they demonstrating bias or not? Probably that's what you're saying. The other question of pressure is a separate question altogether.
Indeed.
So due process, that may be an additional ground. So the question before us is, do these words in themselves, these are not words, what I've said subsequently in a judgment or in a book or something like that, I may have forgotten what I've said, but this is what I'm saying in the judgment. Does this demonstrate bias or not? Probably that's it. And if it demonstrates bias, then the due process fair trial requirement may be vitiated or undermined or absolutely done away with. I don't know. So sorry, with respect to my learned colleague, can you just...
So adding to that, I mean, if there are two grounds now, one is that there is a pressure on the bench, that's totally extraneous to the case, that's one. The other is that the bench, the judges themselves are biased. Now, first of all, that bias issue was taken up in review and must have been sorted out. But still, if you think while deciding the review there was bias, you must have some independent evidence today to establish that there was bias. Because like this, every case could be opened up on the ground
That's
of
very
bias.
fair. But
Review में ये touch हुआ था? Review में did they touch upon this?
The Supreme Court review was very limited. But
No, was this aspect, as my learned colleague has pointed out? Huh?
Supreme Court was
In review was it touched
That
upon?
was available to you. You
review
could have
tha
said
unanimous.
that ground was available to you. You said they were biased, but that ground was not taken.
So I'll explain. The judgment of Supreme Court, detailed judgment, addresses all those questions. Now, the review was on a very limited ground, but two submissions. First, as my lord observed, if your lordship will recall, in Asif Ali Zardari case, only one judge was found to be influenced. In Pinisha case, only one judge of the House of Lords was found to be affiliated. That led to annulment of entire judgment. But most interesting, if I may tell your lordships, more grounds that judges were not independent or independently appointed. Majority of them were ad hoc judges who
Well,
hanged
that's
Mr.
point,
Bhutto.
sir. We'll come to them separately.
Khalid, what were the grounds of review then?
Sir, वो तो बड़े limited ground पे था.
क्या limited ground?
On the merits of the case, not all these.
Merit of 22 का ground आपको available तो था ना? 22 का ground जब
Bias का ground तो है ना. It's
Sir,
not
sorry,
merits.
they didn't seek
Mr. Khalid
review.
Javed, can I come to your rescue?
As always.
Arguing the review before the same bench and saying you are biased would be pretty, maybe not appropriate, because then you
No,
are
that's a
limited
legal
relief.
ground. That's a legal ground. You could take it.
Let's hear these.
Ground to
we are
take.